Does our Constitution require churches to recognize the validity of same-sex marriage? Or will churches that refuse to recognize the validity of such marriages find themselves standing against the law of the land and a sweeping tide of public opinion in the U.S. favoring such marriages? Hello, I'm Larry Crain, founder of the Church Law Institute, with this live report today from the U.S. Supreme Court. Today, the court heard arguments in a challenge to the Defense of Marriage Act, or DOMA. And this act was signed into law in 1996 by then-President Bill Clinton, and Mr. Clinton has since publicly disavowed the act, stating that had he had this to do over, he would never have signed this bill. The case before the court today is called U.S. versus Windsor. Edith Windsor is seeking to claim a marital exemption from the estate tax based on her same-sex marriage to her deceased partner. The Internal Revenue Service has denied her this exemption based on the application of DOMA. For more than 2 centuries after our nation's founding, every state and the federal government has defended marriage as defined as the legal union of a woman and a man. Today marks the first time in our country's history that the President of the United States has taken a position in court against this traditional understanding of marriage. Likewise, Vice President Biden, who voted in favor of DOMA in 1996, and a majority of the Democratic members of the House and Senate have all called for its repeal. Now, in simple terms, DOMA leaves to the individual states the freedom to choose whether they will recognize same-sex marriage from a sister state. Under DOMA, no one state may force upon another its decision to adopt a new definition of marriage to include same-sex unions. Today, the court is being asked to decide whether this system of deference to the individual states is unconstitutional because it denies equal protection to a certain class of people in this country, namely those who seek to marry within their gender. Today's argument centers around what level of scrutiny the court must apply to these laws. So what does all this mean for churches in America? First, if it hasn't happened already, your church will soon be called upon to take a public position on the issue of whether it approves or recognizes same-sex marriage. And while certain decisions, such as the ordination of gay clergy, are for now at least protected under our Constitution, decisions of who a church may employ in non-ministerial roles is not so protected. If the court today decides to elevate sexual orientation to the same level of constitutional protection as race or gender, then your church ministry could be sued should it refuse to hire an individual who is a member of a same-sex marriage. Secondly, once your church does take a stand on this issue, it will inevitably alienate some sector of the community, both outside and within the local church body. Polling indicates in 2011 that the proportion of Americans supporting same-sex marriage has increased from 27% to over 53% in a span of only 16 years. This means that there will be an increased likelihood of church splits over this very issue. Church Law Institute will be addressing this issue head-on in our upcoming seminar in June of this year, and we will be examining ways that your church can prepare itself in this rapidly changing area of the law. If you would like to learn more, please log on to our website at churchlawinstitute.com. Thank you.